Welcome to Solutions with Courtney Anderson. I am your host, Courtney Anderson. Today's show is part of our Law Lovers Lounge series. And of course, our Law Lovers Lounge is for all those of us who love the law. It excites us, it's interesting, it's fun, and it also makes sure that we are able to be treated equally under the law. One of the things that's really exciting is the ability that we have to know and to trust that if something goes wrong, I have a way to be heard, a way to stand up for myself, a way to ensure that I'm treated fairly, and that's the legal system. Of course, in parts of the world and parts of all countries have parts where the system doesn't work like it's supposed to. There might be corruption, there might be nepotism, and then a person feels, and in fact not just feels, but knows, I can't trust the law. It doesn't work for me. And then often people then take the law in their own hands, and that's where you get sort of vigilante justice, street justice. People just go out on their own and say, there's nobody that'll help me. I'll just have to do it myself, and punish the people who I think have done bad things to me. That, of course, is very dangerous and unstable, but that's sort of big picture why we love law. So here in our Law Lovers Lounge, again, this is a lounge. We're just sort of relaxing, we're talking, we're sharing. This is an educational general overview. I just have to clarify, make the disclaimer that although I am an attorney, I am not your attorney by virtue of you taking part in this program. That's really important. And, of course, people who have signed client contracts, client representation contracts with my law firm, then they would be a client. But this is not, this vehicle, this show, this episode, it is not the delivery of legal services. It is an educational program discussing some legal aspects in hopes of general education and knowledge in the broad public. And so our topic today is an interesting one. It's a nuanced one, but we'll try to give an overview in this episode. And so the show episode today is, should I take a plea in my criminal case? Should I take a plea in my criminal case? And the idea here is that we're talking about people who have a criminal legal case. So criminal cases are cases where the punishment can involve paying money, usually fines and governmental fees, and it can involve incarceration. And that is the loss of my physical freedom, where I would go to a physical building and stay in that building as punishment for the crime that I've done, the crimes against society. And so typically in the United States in general, if the maximum punishment is up to a year in incarceration, then that's typically called a misdemeanor. If it's more than a year, and it can be up to, depending on the nature of the charge and the penal code, it can be up to life in prison, where someone goes to the building and they stay there as punishment literally until they naturally die. They just stay there forever. So that's why it's called life. It means the rest of their life. And they never get to leave. That's their punishment. And some people in a very few parts of the world, and in some systems, including the U.S., then the punishment can be up to enforced death, where the government doesn't sort of wait out someone's natural life, but the government actually kills the person, and they have different methods. Some places hang the person, some places shoot the person, some places poison the person. The lethal injection is poisoning the person and to kill them. So they're all different options. But criminal cases typically get people's attention, because the punishment, of course, is the loss of your freedom, and you don't have the ability to be out in society or live where you choose, but you're housed in this correctional institution for some period of time, depending on the nature of the charge and your punishment. Also, there's something in society, just sort of, I think, our human the sort of the basest part of kind of what we are capable of as people. And so there's sort of a natural, curiosity, I guess, in the criminal system, because that's where the most horrible things people can do. So you imagine the most horrible thing somebody can do, whether it's physically harming another person, a sexual offense, extreme economic and financial offenses. These are the most horrible things that people do. That's the criminal justice system that deals with them. And so there's all kinds of media and movies and TV shows about crimes, and there's the whole media outlets, all they do is talk about crime all day. Some of them are sort of fictionalized, or they have actors and actresses they hire to sort of act out what allegedly happened. And then some of these are actual where they show the real footage of the person, the actual events that took place. And it's I think part of it is that it's sort of the worst part of our species. I think also part of it sometimes is and I'm not even sure how healthy this is, or if it is at all, is sort of thinking, well, thank goodness that's not me. Thank goodness I'm not a victim of that horrible financial criminal, Bernie Madoff or someone, or thank goodness I'm not the one who that person murdered or whatever. I think it's that, and then of course there's also just the public function of shame on them, shame on them for doing the bad thing. So this is an area of great interest, and our show topic is for people who are in the criminal justice system. What should they do in terms of outcomes? And so the question is, should they take a plea? What does that mean? What does that mean? In general, what happens, big picture, so someone is accused by the government of doing something allegedly that's a violation of a criminal law. Okay, that triggers an arrest, or it triggers a warrant for somebody's arrest. That's a piece of paper basically that goes out and says, this person has allegedly done this bad thing. Here's the identification of this person. And then the police either arrest the person, or sometimes the person's aware of this and the person comes to the police or local law enforcement and turns themselves in and says, oh, I'm aware there's a warrant out for my arrest and I'm here to turn myself in. The arrest just means that they're accusing you of doing something, that the government, that's who they are, is accusing you of doing some bad thing. If it's a federal offense, then the entire society is accusing you. So in the United States, the paperwork would read, the United States of America, versus Courtney Anderson. So the defendant is the person who's defending. The plaintiff or the prosecutor, that's the person who's bringing the charge. They're the ones that are on offense, basically. I hate to use a sports metaphor for a couple reasons. One, sports not really my strong suit. And secondly, I'm not really sure it's the most accurate, but I think it's somewhat helpful. So the prosecutor, the plaintiff, is the party that brings the charge. They have to prove it. That's their job. Prove it. The defendant, in theory, just defends. In theory, the defendant doesn't have to prove anything, right? I'm just defending myself. You have to prove. In criminal cases, there's a standard that has to be met to, quote, prove it, right? And most criminal cases, it's beyond a reasonable doubt. So the idea is that you have to show beyond a reasonable doubt, not beyond any doubt, not beyond all doubt, okay, but beyond a reasonable doubt that I'm the one that did this bad thing. You have to prove that. The defendant, in theory, again, doesn't have to really do anything. They're not supposed to, in theory, but in real life, if they go to a trial, then especially if there's a jury, then the jury wants to know kind of, what's going on. What's your theory of the case? What do you think happened? If it wasn't you, who was it, right? All right, so there's a lot in there I need to explain. Okay, so the idea is that there's a criminal case. We talked about that, the difference in general between criminal charges and civil charges, that criminal charges include incarceration. If it's up to a year, it's usually misdemeanor, over a year, felony in the U.S. Civil cases are all the other areas of law where you don't go to jail. So you're getting divorced, it's a civil law. You have a contract problem, that's contract law, but it's civil law. You slip and fall, civil law. So everything else is civil law. All right, so criminal law, by the time somebody's asking, should I take a plea, that means they have been arrested, right? The arrest is just an accusation. It doesn't mean that you did anything. It doesn't mean it was you at all. So that doesn't mean anything. So an arrest is stressful, and it's not the best use of somebody's time necessarily, but that doesn't mean anything at all. And you shouldn't feel concerned or stressed out. Sometimes as a lawyer, people would get so panicked about an arrest, and I'd say to them that this is just an arrest. It's nothing. Not meaning it's nothing, not meaning that it wasn't stressful, not meaning that it wasn't, a horrible, experience. What I'm saying is that no one's legally allowed to deny you, housing or a job because you were arrested, because an arrest is an accusation. And again, it often happens. It happens often where somebody was arrested and it wasn't them. It was either wasn't them or nothing illegal actually happened or whatever, and the case is, just dismissed, just dropped because, mistaken identity, or we're sorry, or oops. And you see this all the time in the media. There'll be a big, huge media story where somebody's been in jail, for a really long time, often, decades, and then now we have more modern scientific process, and so they'll have like a DNA test, and it'll turn out that the person who's been sitting in jail for 30 years for supposedly doing this horrible crime, it wasn't them because we did DNA, and it turned out it was somebody else. It wasn't them at all. And then they're exonerated, right? We're sorry. That's where the government comes back and fills that paperwork, and ideally the paperwork is explains it wasn't you, we're sorry. And then they're let out of jail, and it's usually covered on media because how awful, right? Oops. You were in jail for 30 years. Sorry. It wasn't you. You're free to go home now. Sorry about that. And the poor person's lost all this time, in their life. Wow, really? So mistakes happen. So the arrest in and of itself, don't panic or get upset or freak out or anything. I mean, it's stressful, but it doesn't mean, obviously, that that it's anything negative, and it certainly isn't anything that's allowed to be used against you in your real life, because goodness knows it doesn't mean that the thing that is accused actually happened or that you did it or anything else. Okay, so after the arrest, typically if you're arrested, so then you're at that time held. Sometimes it could just be for just a little while, maybe a few minutes or a few hours, and then you're formally the charges are read. So you're arrested, then you need to typically go before a judge, right, and be arraigned. And ideally, then the judge, somebody's going to determine, a judge or hearing master is going to determine if you're eligible for release pending this case moving through the criminal system. So there's been an accusation that you did this horrible thing. Okay, nobody knows at this point if that's true or not. I mean, but okay. So then I'm arrested. Oh no, I'm here in jail. I want to go home. This is horrible. I'm stressed out. Okay. Often at that point, the lawyers are hired, and the lawyer's going to try to expedite, to speed up the formal required process for a determination to be made whether or not you're going to be held in jail without the opportunity for bail until your case is actually all the way through the legal system. That is very rare. But if you have a really serious crime, these are going to be serious felonies, then it's a possibility. Then the government will say, hey, we can't even risk letting this person out of jail at all. That we don't trust that they're going to come back to appear, for the other hearings and for trial, and or they're too much of a danger and a threat to the society. That's a very, very rare situation, but I have to mention it because it does happen. On TV, you see it a lot on TV shows or movies or media, because it's dramatic, but it's incredibly rare that happens, that somebody's not eligible for bail. But it does happen. So depending on your situation, that'll largely impact whether or not you're going to take a plea. All right, but again, that's a very serious situation in terms of the crime, in terms of the facts of the situation, in terms of also your individual likelihood of appearing. So if you have a long record of prior convictions, if you have a history of failure to appear in the past, if you have multiple passports and the ability to access funds and sort of disappear, then these are all things that the government's going to look at. Okay, so the arrest, okay, then you're held for some either really short amount of time, or in theory you could be held all the way until your case is determined at the end of the trial. But typically you're released on bail. So they make the determination, okay, is there going to be no bail, which happens very rarely, but does happen, or we're going to go ahead and let the person out on bail, or sometimes they'll let the person out on what they call their own recognizance, which is basically like, hey, just make sure that you show up for this stuff in the future, and you don't have to pay any specific bail amount. Those are going to be very low-level issues. Remember, you can be arrested for, somebody got a speeding ticket, and the paperwork said on the speeding ticket you have to pay your speeding ticket, within a certain amount of days. And the person just, lost the ticket or just, never paid attention to it. They didn't pay their speeding ticket. And the speeding ticket was, I don't know, $40, but they just ignored it or whatever, or lost it. Then what happens if you ignore that paperwork, then at some point, and you never entered a plea on the speeding ticket, even though it seems like it's not a big deal, what will happen is if it's totally ignored, it will go to court. There's nothing that anyone's heard from you, so the judge is going to go ahead and convict you of the speeding thing. And since you never showed up or paid, at some point, it's probably going to trigger an arrest warrant. Now, it sounds a little silly, like why on earth are people putting arrest warrants on something so small, like a $40 speeding ticket? But the reality is that the government they're going to get your attention. You're going to have to follow through and pay the consequence. So maybe it wasn't even a speeding ticket. Maybe it was a ticket because you were pulled over and you didn't have the right, insurance paperwork showing that you have insurance. But you really did have have insurance. You just didn't have your paperwork. Well, there's rules about how many days you have to show proof of insurance, and they'll dismiss the case. But if you ignore these things with the legal system, then there's a consequence, and the consequence gets worse and worse. So people can be arrested for things that are, horrible, awful, suspected mass murderers or whatever, with no bail, and then they can be arrested for, maybe they claim they didn't have insurance or it was a speeding ticket or whatever, and it was a really low-level misdemeanor, but they ignored it, and so there was now a conviction, and now there's a warrant out for your arrest. Okay, so that's a huge spectrum, right? That's why there's a huge spectrum of you can just be released on your own recognizance. Hey, make sure you show up and pay your speeding ticket, or show that you have your insurance or whatever, or up until you're not getting out at all on bail until you've been acquitted at the end of a trial. And when you're asking the question of should you take a plea in your criminal case, the challenges in doing programs like this, sort of generic, broad programs, is that's a huge spectrum, So if you're on the low end of that spectrum and it was a minor misdemeanor, it depends on what your outcome goal is. Remember, so there's the arrest, the accusation, and there's an administrative process where the person is brought on the charges informally. The charges are brought. The determination is made if they're going to be released at all, if they're going to be released on their own, or they're going to be released with a bail. Bail is that, hey, you can be released when somebody puts up this amount of money or surety. So, the own recognizance usually is, okay, just make sure you show up in the future for your court dates. Bail is, hey, somebody needs to put up, $75,000 and then you get out. Until somebody puts that money up, you're not going anywhere. A lot of times people don't have the cash to put up the $75,000 or whatever the bail is, so they'll go to a bail bonds person. Bail bonds person, their job is exactly what it sounds like. They put up bond. So you don't have $75,000. The bail bondsman usually they say, we'll take 10%. So I need $7,500, not $75,000. You give me the $7,500, I'll put up the bond saying that you're going to show up in court. And then as long as you show up in court, then everything's fine. The problem is if you don't show up in court, then the government says, okay, you didn't show up in court. That's why they're asking the money. The money is a way for them to try to compel you to make sure you show up. Because if you don't show up, the government is going to take that money. And then, of course, they're going to put a warrant out for your arrest. And so bail bondsmen, when you see they have media and television shows and things about bail bondsmen, what happens, the bail bondsman is the one who says, look, I'll go ahead and vouch for the full dollar amount, even though they only got like 10% up front. And, of course, whenever the client shows up, it all works out, right? Because the bail bondsman made money on the case. And the person showed up, so, the bail was satisfied, and so at the end of it, the bail bondsman's made a little bit of profit on it, and it's a win-win case, right? And the person shows up. When the person doesn't show up, the government says, okay, fine, we want our whole $75,000. Now the bail bondsman's on the hook for that, and they want their money. And that's why you see them out, like, tracking people down and everything, because they want their money. I want my money. I will admit this, when I was very early practicing law, in the jurisdiction I was practicing in, they had a situation for a little while where they would let a lawyer sign somebody out. I could basically function kind of as a bonds person, and just on my own signature, I'd say that I'll take responsibility for them, right? The risk of that is then I was in the same position the bail bondsman was. And I did it a few times, and I said to my client, like, look, I'm on the hook now. If you don't show up, I'm going to be on the hook for the full money. And it was just way too stressful because I'm not a bounty hunter, and I just can't. I couldn't handle the stress of that, and fortunately, I made decent enough choices where people did show up. I never had a situation where somebody didn't show up and then I was on the hook for the whole amount, but it was just too risky. So that's not anything I've done in many, many, many years. But I was in that position, and it's a frightening position economically because you're all over those people, in terms of communicating, reminding them, because they have to show, and you've got to show up and tell me what's going on in court so that I'm not financially on the hook for this. Okay, so you're trying to decide, should you take a plea? We want to be really clear. In the United States, okay, we've had the arrest, we've had the arraignment. Most likely you've been released either on your own recognizance or with bail. And now we're getting ready to move your case forward. Now, your case moving forward means exactly what it sounds like. The idea is the government says you did this bad thing, right? That's what they accused you of and arrested you. At some level, at the end of this, they're supposed to prove it. So ideally, the government said you did it. All right, then prove it. That's what trial is. Trial is where they go prove it. The trial is when they prove it. Now, the challenge in real life is that there's a huge difference in time between when you're arrested and when you can actually have a trial. You don't get arrested on Monday, bail out on Tuesday, go to trial on Wednesday. For most cases, it might be if it's a low-level, traffic ticket type situation, they might have a really quick trial setting, but that's unusual, and that's going to be for a very low-level case. If it's a more substantial case, it's a high check, it's an assault, it's a terroristic threat, it's possession of, either alcohol if you're a minor, or possession of some other illegal drug or substance if you're older than that. It's driving while intoxicated. All these sort of basic garden variety crimes. It's a while. It's going to be a gap in time between the arrest and then you being released, and then you actually go into a trial. Why is there a gap? Because these are government functions. So the courthouse, the judge, everybody's paid by the government. These are we, the taxpayer, pay for all of this. We build the building, we pay the utilities, we pay all their staff. We pay them, and so basically they have one functioning court outlet, and then all the people in that geographic area get funneled through there. So there's usually just a backlog. This is the numbers thing. It's usually just that there's not enough judges in courts to hear all these cases. And so you have to wait your turn. And while we're waiting to see if the government's going to, go to this thing called the trial, which is what you see on TV, right, where they get up, they have opening statements, they're, typically on TV and movies, there's a jury brought in, just sort of random people off the street, and then they're going to listen and make a decision. To get to that, it takes a long time because there's all these other cases. And what tends to happen is while we're, in theory, the case is on the calendar and it's moving toward trial, but they'll have what earlier settings, like first appearance, for example, second appearance. And in these appearances, what happens is the government's saying, look, we want to make sure the person, is in the area and showing up. So, and if you are on bail, then your bail bondsman's concerned about this. So the defendant shows up, the lawyer shows up, and typically what the lawyer's doing is this. The lawyer's going and talking to the government lawyers, right? They represent the government. They are paid by the government in almost all instances. That's like their full-time job. They have benefits, health insurance, and vacation and all this kind of stuff. Most criminal defense lawyers in most parts of the country are either work for themselves or they work for little, small law firms. So they're not government employees. They don't have usually the same types of resources in terms of, having a whole power of the government behind them. And so the defense lawyer goes and tries to negotiate with the prosecutor and sort of come up with the outcome their client wants. So if the client says, hey, I would like this case to be dismissed. I don't mind if I have to take some, classes and promise not to, speed again. Usually they'll have, defensive driving classes. They've got classes for almost every type of these crimes because that's a whole other little cottage industry, right? So a class on anger management, a class on parenting, a class on, drug and alcohol abuse, a class on hot check writing. There's just all these classes. And then the person says, I'll take the class and I'll pay a fine and I'll stay out of trouble, for whatever, 12 months. And at the end of that, the government agrees they're going to dismiss my case. That's very common. And there's a deferred adjudication or deferred prosecution where basically I'm going to defer or put off, adjudicating, having a legal determination, or I'm even put off prosecuting, right, moving forward to the case. And as long as all these conditions are met, the person takes the classes, sometimes has drug counseling or alcohol tests, and pays some fines and whatnot, stays out of trouble, then at the end of this certain amount of time, all those conditions are met, the case is dismissed. So in the issue of should you take a plea, the bottom line is about 90% nationwide in the U.S. About 90% of criminal cases are pled out. So this is what happens 9 out of 10 times. In some jurisdictions, it's much higher than that. Some cases, you'll go to some areas and it's 98% of cases, 95% of cases are plead, or there's a plea that's on the case. And so the thing where you go to trial, where you're in that really like in a movie or TV, where the lawyers are there and they're like giving these great arguments, and then the jury is like, what's going on? Like, that happens so rarely. On average, it happens, somewhere between 1% and 10% of the time. It's just really rare, because it's incredibly time-consuming, right? You have to have that one judge where you have all the other cases, but that one judge has to spend all their time on that one case because we're in that trial, right? And then we got the court reporter, and we have the other court staff, and we have the bailiff and the constable, and then we have the prosecutor attorney or team of attorneys. You have the defense attorney, or sometimes you'll have teams of defense attorneys, and you have to go get a jury and impanel a jury. I mean, all this is incredibly time-consuming, and it sucks up resources, because all that time that's spent on that one case while it's in a trial means that you can't be processing all these other thousands of cases or hundreds of cases that are sitting and waiting. So they're rare. And so what happens is the defense lawyer is going to court multiple times over a period of time, usually months, sometimes years, and keeps meeting with the prosecutor, saying, what do you have for me? And then the prosecutor usually will say, well, here's my recommendation. And they'll just tell you, we offer, 6 months in jail and a $2,000 fine. And then you say, defense attorney says, well, no, my client wants this to be dismissed. And they're willing to take a deferred on it, but there's, of course, in that would be no jail. They'll take some classes and pay some fines and stay out of trouble. So then when the two parties get to a point where the offer that the government makes is what the defendant has told their lawyer that they want, then they just accept that. And then the defendant signs the paperwork saying, usually, okay, I'll accept the terms of this plea, and usually the majority of people want the case dismissed at some point. Now, some people I did another show recently in our Law Lovers Lounge, and it talked about how to hire a criminal defense lawyer. And in that show, I talked about the fact that some people don't want to do deferred or deal with all these requirements because they don't have, consistent transportation or income, and they'd rather just go to jail. So some people would plea on a case immediately and say, hey, I'll just go to jail for 4 or 5 days and have the case over with. Now, then they have a conviction, which is a big part of deciding if you want to plea. If you have the money and the time, then I would suggest then you're going to go to trial. Most likely understand that you're probably not going to get to trial, because as you get closer and closer to your trial setting, what will tend to happen is the government will become more and more amenable to listening to what you're asking for, and you'll probably still plead the case out because it's so risky when you go to trial. Nobody knows what the outcome will be, right? That's why the public loves these things. They're really rare, but there's nothing the public loves more than, oh my goodness, look at that big thing that was on TV in that trial, and that person totally guilty. We all think they're guilty, and look at them. They walked. They're out. They were acquitted. Acquitted means you went to trial, and the jury said, nope, they didn't prove beyond a reasonable doubt it was you. In the U.S., an old case now at this point, but the O.J. Simpson was a famous professional football player, and then he was an actor, I think, and it was a big case, and he was acquitted on a criminal case, murdering people. Walked out. They said it wasn't him. That is a big example of what can happen. That's why prosecutors know it's risky, and it depends on the facts of the case and their office deciding it's worth it. And everybody, the defense attorney knows how risky it is too. It's incredibly risky. So if you get the plea that you wanted, even though now you're mad, and I've had this happen, people with a lot of financial resources, we're going to go to trial. Okay, fine. So we get to the day of the trial, and we're getting all, set to start, questioning members of the public and see who's going to be on our jury. It's called voir dire. And then that's where the government comes to me and says, oh, okay, now we're willing to give your client what they wanted. And sometimes my client says, well, no, I'm mad now. Let's go to trial. I'm like, no, you can. I'll do what you want me to do, but they gave this to you. So bird in hand, take it. We go to trial, and you may lose, and you may end up in prison. Where now you got a way you can walk away from this. So don't ever get emotionally on these things. If you don't have the money and the resources, then take the resources as far as you have. Go as far as you can with the limited budget. Talk to your lawyer and be totally upfront, and let them know. And what I mean is, let that case stay on the calendar for trial as long as you can. Come up with a little bit of money for your lawyer to go and see if you can get better opportunities for a better plea. If it comes to trial time and you don't have a good plea offer, then go to trial. But you need to have hired a lawyer from the outset, or have hired a lawyer as you went along that you know is a litigator. There's a very specific skill set for sort of the performing part of being in trial, which is totally different from what most people do in life in general. So you want to make sure you found the specialist. They usually charge more, but if your life's on the line, then you pay whatever you can. Again, I want to add, the criminal defense lawyer, even with all the money in the world, cannot work miracles. I mean, if there's witnesses and pictures and video of what you did, and you still go to trial and hope for the best, and sometimes it happens, but they're not magicians. They'll do everything they can, but reality at some point is going to have potentially some impact. So there you go. Do you have the resources to push your case as far as you can on the calendar? If you get what you wanted or close to what you wanted, take the plea. And I would strongly recommend that you try not to have a conviction on your record. Thank you so much for joining me, and you can always come to CourtneyAnderson.com.